Hi, everyone. I'm Annette Pinyazic. I'm the Director of Grants and Major Gifts for Houston Area Parkinson's Society. We really appreciate you joining us today for our estate planning education webinar. We launched this series in response to requests from our community members who wanted to have more information about estate planning. And our presenter for this series is Kathleen Wiesenthal, who is an attorney with Keever and Wiesenthal. And Kathleen's practice focuses on probate, real estate, and estate planning. And today she's going to talk about life-proofing estate plans. This is a continuation of a topic that we had for our last webinar, which was in October of 2025. And that's available on our On HAPS's YouTube channel. Now we're going to reserve some time at the end of this presentation so that Kathleen can take questions. And if you have a question, just please add them to the Q&A. And you can do that at any time. And then once Kathleen has finished her presentation, we'll begin the Q&A time as well. Now, today's webinar is being recorded. And there will be a link available on the HAPS.org website and on the HAPS YouTube channel. It'll take us a little while before we get it up there, but it will be available shortly. So I'm going to turn everything over to Kathleen. Kathleen, thank you so much.
Thank you very much. I'm looking forward to doing this again. And I'm going to touch on some of the items that I touched on in October because people actually had a lot of questions for me along those topics. So I'm going to touch on them again to bring it back to mind if anybody is following these presentations very closely. So I want you to know that I haven't forgotten what I gave you guys last time. So let's go and share my slideshow. And some of what we're talking about here, hold on just a second. It wants to go back to the beginning. I apologize. Stop share. Some of what I'm touching on is not the happy part of probate and estate planning. We need to make sure that we're going by looking at all of the, hold on just a second. I'm so sorry that this is not going as planned. All right, let's try this one more time. Okay, so sorry to waste your time. Give me 2 seconds to just get this going here. It was working a second ago. And okay, so one of the things that I'm going to be touching on is how things can go wrong when you think you've done everything right. And it doesn't mean that there's demons sitting around every rock waiting for you to fail at this and then have your whole estate plan be completely let me see, new slides. It doesn't mean that it's waiting to go completely bad. You have the ability to begin your estate planning. And once you've done that, if you're doing it with a professional estate planner, then you are going to have all of the tools that you're going to need to be able to make sure that these potholes don't happen. We originally started with the title of sinkholes of estate planning, but It's only a sinkhole if you're trying to do it by yourself. The only pothole might be if there are some facts you haven't shared with your estate planner and that you have the issue of dealing with not telling them everything that is important in the planning of your estate, including the character of your assets, um, the ability of your executor to be able to handle your estate. If you've got beneficiaries that need special handling, those are all important issues that you've got to share with your estate planner. So, what kind of things can go wrong? If you become incapacitated and no one can pay your bills or handle your legal matters, it means you haven't done something correctly. And incapacitated could be a short-term incapacitation or a long-term incapacitation. Basically, what it means is that you are incapacitated from being able to handle any of your own complex financial or legal matters. What happens if you are hospitalized and you have designated no one to advocate for you while you're sick? That sometimes isn't a problem. If you have a relationship with your hospital or your doctor, they may talk to your spouse or your children. But if there's any decisions to be made and you're not able to make those decisions, they may not accept those decisions from anybody else unless you have medical powers of attorney. Let's say you have no will and you think your estate assets are going one way, but they're really going the other direction. Those are things that I can fill you in on so that you're not unaware of what the law says, so that you have the tools in your estate plan to make sure that everything is going where you want it to go. Types of powers of attorney, I've touched on this before, are the statutory durable power of attorney, which is the power of attorney that gives your agent the ability to handle financial and legal matters. It's a pretty powerful document. It is not to be taken lightly, and it's very important that the document be filled out with an attorney going over each of the relevant paragraphs with you. This is not something you want to fill out on your own if you're trying to do this on the internet. And I'm not just saying this because I'm an attorney and that's how I make my living. I'm saying it because it's very, very important. There are a lot of problems that we'll go into in a durable power of attorney that can crop up if it's not done correctly. So keep that in mind as we go through the slides. The medical powers of attorney, I just explained that if your doctor is willing to talk to your family and if they're willing to take very serious decisions from your spouse or family, then you probably won't have an issue. But if you end up in a hospital where you don't know the doctor and you don't have any powers of attorney, the doctor's not going to know who to turn to if you can't tell them what your decisions are. And everybody says, oh, that's never going to happen. Well, guess what? It does. And you don't plan for that. It happens within seconds, and then you're in that situation. A HIPAA release, I threw that in there because I wanted to make it clear that a HIPAA release is very often enclosed in a medical power of attorney. However, the HIPAA can be done as a separate document so that if you have people in your family that you send to get your prescriptions or talk to your insurance company, maybe you've got a caretaker who helps you talk about, contact your insurance company about claims and things like that. You would probably want to give a HIPAA release to those people. HIPAA is the Health Information, I had to think about it for a second, Health Information Privacy Act document. And that is the document that allows third parties to rely on the agent you have selected to be the person to release information to. Otherwise, they are in defiance of that law and they can get in big trouble. So you've got to keep in mind that maybe you're okay with your daughter going to the pharmacy for you, but the pharmacist may not know her and really needs some protection for their own liability to make sure that it's okay to discuss your prescriptions with her. And that's the document that will do it. Okay, so some of the things about POAs is don't assume that you can use a power of attorney to sign a power of attorney. You cannot. Powers of attorney have the ability to act on behalf of you, but they can't give anybody else any legal rights or authority over your transactions, financial information, legal issues, things like that. So don't assume your POA just gets to do everything because that's not how it works. POAs are relied on by third parties. That's why they're so important. That's why the statutory durable power of attorney is called that. They didn't just call it that to make it a really long name. It's called that because it is promulgated, which means prepared and put forth by the state of Texas, by the legislature. And it has all of the elements in that promulgated form in the code, the estates code. And that is the form that should be used by individuals who are wanting third parties to rely on their assignment of an agent to handle their affairs. It's not something that's taken lightly. A POA doesn't get to suddenly just show up and do things for you. They can only do what you would normally have done yourself. Um, Making decisions for a principal, and a principal is you. When you do a power of attorney, you're the principal. And those decisions can only be made as the principal would have decided. A POA doesn't get to rewrite your life and decide to spend your money differently or pay your bills differently or anything like that. That's not their right. They only have the ability to use their agency to take care of your estate the way you would have done it yourself. They don't get to make decisions for you. That's not what this is about. An agent has the fiduciary responsibility to prevent waste also. So if you've got POAs who are spending your money like crazy, that's not appropriate. That is not correct. There's a fiduciary responsibility is actually a legal responsibility that has liabilities to it. You can go to jail for abusing your fiduciary responsibility. You can be fined, you could be sued, and you could be personally responsible if you are acting in an irresponsible manner for the principal that you're working for. So keep that in mind when you've got a POA working for you, that they don't get to just do what they want. Oh, mom, it's for the best. Or dad, no, you really should invest it this way. That kind of a thing. It isn't necessarily something they're allowed to do without your blessing. Okay. So the powerful document, we just went over that. I'm not going to go into it too much more because here's what I want to tell you about a power of attorney. I'll let you read the slide. But what we're talking about here is when I said that the durable has to be gone over with an attorney. You should not do that on your own because there's a lot of areas of that power of attorney that are not self-explanatory. And if you don't check off or initial certain portions of a durable power of attorney, you have just probably filled out a form that is useless to you or your agent. Don't let that happen to you. Make sure that you've got somebody reviewing the power of attorney that you have, or at least drafting it for you and going over it with you when you're signing. One of the things that people do repeatedly is that they don't make arrangements for their power of attorney to be able to handle all of their matters. There's a list on the durable power of attorney, a list of powers you can give your agent. One of the challenging mistakes that people make is that they only select certain powers for their agent. Now, you have that right to do that. However, you don't necessarily know without legal advice whether or not power B is going to be affected by power D. And are you going to be handcuffing your agent from being able to help you with B if you don't give them the power to do D, that kind of a thing. If you ever have had a chance to look at a power of attorney, I probably should have put one on the slides, but they are complex and they do require you to think about what you want to give somebody else as the ability to help you. Also, one of the things you want to think about is, let's think a power of attorney is for when you're incapacitated most of the time. Sometimes it can be immediately effective, but usually it's effective upon your incapacity. If you have the situation where you are incapacitated and there's a big decision that needs to be made about your estate and financial affairs, know your agent well enough to know whether or not they can pivot. And if they have the ability and the sensibility to pivot to protect and prevent waste in your estate, then there's a particular paragraph in the durable power of attorney that says, I give my agent the ability to make gifts of my property. That is a very important section of a power of attorney. And a legal professional or a probate professional will be able to explain what that means to you and the different circumstances that that might be used under. My whole point being, I don't want to explain the whole durable power of attorney to you today, but I want you to ask questions. I want you to read that and go, should I be signing that? Or why is that showing up here? That kind of a thing. I don't want you to be passive about signing those documents. The medical power of attorney is a little bit more fluid. Like I said, if your doctor knows you and the hospital knows you, and they know you're married to your spouse who keeps coming in the room, and they know your kids because they've been there for a week with you, they might not be so not be so strict in adhering to the medical power of attorney, and they may not even ask for it sometimes. But there are doctors and hospitals that require that before you can be assisted with medical care. In that case, remember that those agents for a medical power of attorney are only allowed to make decisions that you would have made yourself. They can't go bring their own beliefs, agenda, or financial situation into the situation in a hospital room, or in a doctor or an EMT or anything to that effect. So just remember that when you pick an agent, make sure they understand what it is that you want, what you need. If you're sick, if you have the ability to talk to them, make sure that they understand what's going on and how you feel about it. Because a lot of times people just say, I'm fine, when you go into a hospital room. Don't say I'm fine. Say I'm concerned about them giving me this antibiotic, and I really would like you to check on that for me, or something to that effect. But remember that it's an interactive responsibility. Don't expect your agent to be able to read your mind. You've got to communicate with them. Let me see. When to use a POA, the durable power of attorney. It's for incapacity, like I said, but third parties may refuse to accept it. So, for instance, if you decided you're at a point, or when you get to the point of being incapacitated, that you want to give your agent the ability to handle all your banking, keep in mind that the banks may refuse to accept it. They eventually will, In most cases, they always end up eventually accepting it unless there's a serious problem with it. What you have to do is be patient with the bank, let them go through their procedure, which may include sending it to the legal department, waiting. About a week later, the legal department gets back with you and tells you it's okay, or if it's not, and they're supposed to give you a reason in writing. So don't react when a bank gives you a hard time like that, and don't wait till the last minute to go and talk to a bank when you're doing powers of attorney. If you've got your mom's power of attorney, if she's still able to, take her with you to the bank and say, "Hey, I'm going to be the agent. I'm just letting you know, here's the power of attorney to put in her file in the case that she becomes incapacitated," and give them a chance to put it with their legal department, review it, tell you if there's any problems, etc. You have to work with the third parties. The third parties have their own rules. Banks have their own financing rules. Hospitals have their own liability rules and insurance issues. If you've got an investment company, they definitely have their own rules. So you want very much to take into account the people that you're dealing with, the third parties you're dealing with, and make sure that they understand what your wishes are and you find out how their system works because everybody's just a little different. Investment companies are different, they require different paperwork or different, excuse me, retire different paperwork or decision-making procedures. And not everything's going to happen the moment you flash a power of attorney. So make sure that your agents understand that. The medical power of attorney, as again, the in a durable power of attorney, an agent cannot designate someone else to be uh, the agent unless they resign. Okay. They're done in order as opposed to a medical power of attorney, which is a lot more fluid. It will list several agents and the doctors and hospitals, nurses, so on. They pretty much will talk to whoever's available. It doesn't have, there has to be no resignations involved. And medical power of attorney could be any one of a list of 4 people if you want them to talk to any one of them as an individual. And it doesn't have to necessarily be unanimous. It just, the medical power of attorney is telling the third party doctor or hospital, these are the people I trust to make decisions for me. Now, if you want it to be unanimous, tell your preparer of your document that you want all these people to be co-agents. Because then, yes, it has to be unanimous. Now, it's going to make the hospital crazy trying to get 4 kids to come to an agreement about something. But you have to let your preparer know that's what you would prefer. So again, it's talking to your preparer, telling him what your wishes are, telling him how you expect and how you envision it going down when you are sick. HIPAA release, same thing. You can, that only allows information to flow to the agent. The agent is not necessarily giving any information to any third party that this is for, except for that form. But the HIPAA release does not allow an agent in just that document. It doesn't allow them to make any decisions on the part of the principal. I have a mistake in there. It's supposed to say never for decision making on the part of the principal. So remember, it does restrict your agents in some way. They can't just go run your life and make decisions willy-nilly without concentrating on what it is that would be best for you. Okay. Okay, let's talk about guardianships. A lot of people will say, I want to get guardianship of mom. Okay, great. Okay, what is the diagnosis of your mom? What is the prognosis of her situation? What are her current challenges. Can she attend to all the activities of daily living? And what are the rights that you want to take away from your mom in order to be a guardian for her? Because that's basically what a guardianship is all about. You're taking another human being and legally asking to take them into your care, and that you will be making all decisions for them, except for the ones that you accept from the guardianship itself, such as the ability to get married, or the ability to carry a gun, or the ability to drive a car, or make decisions about where to stay, things like that. Those, a guardianship is a very serious relationship between a guardian and a ward, and it's only supposed to be used for the protection of the ward. It is not to make it easier on the guardian. It is not to rein in your mother who is having issues of listening to you, and she still wants to do things her own way, because guess what? She has the right to do it her own way. She also has the right to make very bad decisions. That's her right. Now, if it's spending your inheritance, that's not your problem. If it is putting her in harm's way, or other people in harm's way, that might be your problem. That might be when a guardianship is required. Now, power of attorney doesn't have that kind of power. A person who has a power of attorney for someone does not have the ability to go and put mom in a home because you've got power of attorney. Now, if mom wants to go to that particular home and you are in agreement with her because she still has rights to make those decisions, then the POA may be able to sign some documents for her, make some decisions about the care, how many dinners a week or a day she's going to be having, and things like that. But the power of attorney is not for handling your mom's life and telling her what to do when she doesn't want to do something. I know that's a little vague, because mom might not want to do something 6 times a day, but the rest of the time she's good with everything. But you'll know when there's a situation involved where you've got harm to your mom, harm to the ward, or harm to other people because of that ward not being taken care of properly. When you have no powers of attorney for someone, guardianship may be the only option to help them. Now, again, if mom's making bad decisions, that's not the court's problem. Well, she's spending my inheritance. She's spending all her money. She'll be broke in a year. Okay. But even incapacitated people have the right to live as they choose to live, and to spend their money, the way they choose to spend it. It's a hard fact for a lot of kids to face, and sometimes they just have to back off. Or a spouse, even. A spouse might have to sit back and go, okay, now is this affecting our community property assets, or is it just affecting her assets? That kind of a thing. So these are things that have to be discussed with a professional attorney who does guardianships, and to have that, you have to tell all the details of what's going on in that relationship, what you're concerned about. And if it's purely financial, there may still be the option for a guardianship for someone who is giving their money away or spending it on people on the street corner, that kind of a thing, which is, again, they're right, but let's make sure that she's able to feed herself and able to get to the doctor when she needs to go, etc. You can probably guess where I'm going with this. If there's harm to the individual, definitely think about guardianship or powers of attorney. Powers of attorney can be very helpful in handling and taking care of someone before they become incapacitated, or before a guardianship is necessary. Guardianship is usually necessary if there are no powers of attorney at all, and if there are issues of harm involved. That's usually stepping into guardianship territory because you may have to put them in a lockdown facility to keep them safe from wandering off or hurting anybody and things like that. Okay, the final tips and takeaways. I'm going to skip on this one. So let's go to the will. I have people tell me every single day, I don't want to do a will because I want to avoid probate. I want to do a trust. Okay, that's ill-informed. And what I try to do is to educate people about what a will can do and what trusts can do. Now, trusts, I personally, okay, this is just me as an attorney, I personally only do trusts for three situations. Obviously, I will talk to people about more situations, but these are the main three. If you have a in a minor child, or if you have a incompetent or incapacitated adult or child, for that matter, or if you have a spendthrift in your family, and that's somebody who can't hold a dime in their pocket, they have to spend it. If you are dealing with a minor child, you can't give them anything in your estate, in your will. You've got you can give them something in a trust and designate how that's going to go out to that young person on a regular basis. And when it gets paid out to them, it could be, when they're 25, when they're finished with college, or when they're 25, 30, and 35, you split it up a little bit, things like that. It's whatever you can dream up, it can be put into a trust for a minor child. That is always a recommended opportunity. However, I do wills that contain those contingency trusts because what if there are no minor children when you pass away? What if they're all grown and they're just going to get your estate outright? So a contingency trust doesn't have to be a full-on trust that's prepared by an individual who's charging you $2,000 to do it, and sometimes more. It can be incorporated in your will. Now, let's look at your beneficiaries. This is something that comes up a lot. If you're in a second or third relationship, and each of the individuals, the spouses, have children by other relationships, and maybe also have children together. If you don't do a will, that if you don't designate who's going to get your assets at the end of your life, they are going to go to your children in many cases, okay? Not all, but many, especially with real property. If a spouse moved in with another spouse and it's their second marriage, but only one spouse is on the deed for that house, you want to make sure that when each of you pass away, that you allow for giving the property to whom you want it to go to. So if you want your property, if you're the gentleman and you own a piece of property and your second wife moves in with you and she has no legal hold on the property because she's not on the deed, doesn't matter if she's on the mortgage, okay? Only if she's not on the deed, then your property, if you don't do a will, is going to go to your children. It is not going to go to your current spouse. However, the law allows that your current spouse will have the ability to have what is called a life estate, and they are allowed to live in that property as long as they want. And the underlying owners of that property, which would most likely be your children, perhaps your parents or your cousins if you don't have any children, but there's a different pattern of how your property is moved if you don't have a will. I've got a picture here of a waterfall. That's kind of indicative of what will happen to your estate if you don't have a will. It's going to pour out to all of the people that the estate code says that it's supposed to go to, not necessarily to the people you had always planned it would go to. Now, on the other side, you've got somebody very carefully holding water in their hands, and they're accepting that water before it goes into the big bucket. And you've then, with a will, you've got the opportunity to say, I would like my current spouse to have this house, so that all of your interest is going to go there. Another situation is for community property. If you have both spouses were married when they bought the property, they're both on the deed, you still have to do something administratively, and it doesn't necessarily have to be a will, and there's some other documents you could do. You have to do something administratively to give that property to your other spouse, the surviving spouse. It doesn't automatically go to your spouse. And if I'm a little fuzzy to you on that and getting it confused with a life estate. A life estate only means a spouse who doesn't have interest in the property can stay in the house for the rest of their life and nobody can tell them to leave ever. Even the people who own the property, the underlying kids that own the property, for instance. And the kids just have to wait until that surviving spouse passes away before they can do anything with that property, unless they come to some agreement with the wife. And again, I'm using wives and husbands because that's usually how this works out. If you don't have a will and it goes to your children, then you've got problems with the agenda. Everybody's got a different agenda about what they want to do with this house. Your kids might need to sell that house, and your surviving spouse might be not willing to do that. If you're leaving the house to your surviving spouse, then they don't have to have that stress and worry of paying taxes and upkeeping the house for somebody else who's eventually going to own it, and they're not going to get any equity out of it. So those are the kinds of things you're going to want to sit down and talk with your legal professional about. That's a huge pothole. That can be the sinkhole. There are lots of people who come to me that the wife comes in, so my husband died last year. I've been paying the taxes, and now I want to put the deed in my name, but she's not on the deed. And the property actually is going to go to his children because he did not have a will. The will is extremely important in so many areas because it also gives somebody, your executor, that's the person you assign to take care of your estate in a will. The executor has the ability to have all the legal and financial authority that they need to wrap up your estate and make sure that those items in your estate are going to go to the people you have said they go to in the will. And if they don't, somebody, another beneficiary or a family member, even anybody who's interested in the estate, can sue to get the items in the will distributed properly if it's not done properly. That's the beauty of doing a will and doing it in the courts, because there is some court supervision. Same thing with creditors. When people don't think about that much, but if you pass away and there are creditors in your estate, if you haven't probated a will, if you haven't done a will and filed it with the court for the court to administer, the creditors then have a way to in an orderly fashion, ask for their money through the court, and only secured debt is required to be paid out of an estate. If there is unsecured debt, it falls towards the bottom of the eight. There are 8 hierarchies of creditors to be paid, or bills or debts to be paid. Unsecured creditors like credit cards fall towards the bottom. But guess who else is at the very bottom? Beneficiaries. So you don't want to an executor is not going to want to make a poor decision and give money to beneficiaries when there's still creditors in an estate. That will get them sued. So let's look at a will as a proper legal procedure for making sure that your estate goes where it's supposed to go. A trust, I have all sorts of reasons why you shouldn't put your property into a trust, and I can talk to you about them if you would like to. Part of that being capital gains. That's something that should definitely be considered by anybody putting property into a trust, because you just messed up your kids for being able to use the step-up basis in capital gains. Your children only get a step-up basis in capital gain when they've inherited the property, only upon your death. If you give the property to them, you're giving it to them at the basis that, well, it's arguable that it could be the basis of the day you gave it to them, but it's also could be argued that you're giving it to them at the basis at which you bought that property. So if you have a $250,000 piece of property and it's now worth $1 million in Houston, Texas, your kids are going to have to pay those capital gains because you moved it to a trust. Those are the kinds of things you need to talk to a professional about. Do not get sucked into, I don't want to do probate, because that's not realistic. And a probate and having a will and an executor who is under the supervision of a court is extremely important to your estate. Hopefully, you never need that supervision from the court. But if it becomes necessary, at least your beneficiaries and your estate are safe because there's an overseeing entity that is taking care of that for you. All right, that is all I have for today. And I would love very much to take some questions if anybody has any.
Yes, indeedy. We do have quite a few questions. Thank you so much, Kathleen. The first question that we have is, my home is in my name and my daughter is the trustee of my trust. When I pass on, may my home continue on as she is now the owner of it, or should I add her name, the daughter's name, on now as the owner of it with me?
Okay, there's a couple different answers for that. One is, did you already actually title your home in the trust's name? So is it titled as the Jane Doe Trust, and that's who is the owner of the home, both with the appraisal district and with the real property records? That's important. If you have, that means you've already changed ownership of that property, and that your daughter may lose the step-up basis for the capital gains issue. Again, that's going to be a CPA question. I'm not a CPA by any means, but that is a CPA question you might want to have a conversation with them about and see whether or not it's worth bringing back into your state, or if it's too late. It might be too late. Putting your daughter on the deed now is a gift to her. She does not get the step-up basis at all if you give her that property now. Only as an inheritance will she take that benefit of a step-up basis. If you give it to her now as a gift, it may be considered a taxable gift. So you'll have to, again, talk to your CPA about that and find out whether or not that's going to be a harm to her in any way. Also, if you have an over 65 exemption and your daughter is not over 65, probably not a problem. However, if she's a half owner, the appraisal district has been known to say, well, you can only have an over 65 exemption on half of the house. It doesn't happen often, but it does. So I'm just alerting you to this fact. Putting her on the house, if you've already moved it to a trust, putting her on the house just complicates the issue. So call an attorney or call your CPA and discuss what it is that you've done historically with the title for that house. And then you can make a better decision about what to do about putting your daughter on it. There are some other instruments that you can use to give the property to your daughter if you're worried about the trust not acting properly or taking too long or something like that. And that's also something you could talk to a lawyer about. Ask them about a transfer on death deed. And there again, she'll get the benefit of being an inheritance unless you've already moved it to the trust. But that's something, again, you'd have to talk with your professional about.
Okay, next question is, who is bound by HIPAA? I hear a lot of people say that's a HIPAA violation, but I'm not quite sure who that applies to.
Everybody, it applies to everyone. If I ask an employee um, uh, oh, something about her illness because she's been sick, and I question her about that, that's a HIPAA violation because that's personal information I don't need to have access to. And that could be harassment, it could be other kinds of problems. If your daughter is going to the pharmacy for you and she's asking about your prescriptions because she's nervous about something you're taking, if they give you that information, the pharmacy is at fault. Not necessarily your daughter for asking, but the pharmacy would be at fault for giving that information. I've even seen it where advantage programs or doctors' offices are giving information to family members they have no business giving that information to unless they've got a power of attorney, and they do not. And that can be a real big problem too. But the doctors in the medical field don't always think that that's a problem. I mean, think about it. Do you want everybody that's involved in your life to go and talk to your doctor about your diagnosis? Not necessarily. You would like to keep some things private unless you bring your daughter with you and say, please, yes, you can talk in front of her. So HIPAA applies to every single person, and it depends on who's violating it. But usually you will find that doctors are a little bit more cautious, not necessarily their administrative staff, but the doctors are.
Okay. If I'm awarded guardianship of my wife by the court and something happens to me, such as I pass away,
Mhm.
what happens to my wife? Does she have to go back through the court or does that guardianship pass to somebody else?
A guardianship can only be appointed by a court. There is no such thing as a successor guardian. Now, paperwork may say that. You may say, I designate certain people to be my guardian. And you can appoint successors to that designation if necessary. If something happens to you and you're the guardian of a person, they, the family or any interested party has to go back to the court and ask for a successor to be appointed. If there's documentation, such as a designation of guardianship, which is something that is usually offered in an estate plan, then you can show that to the court and say, back in 1990, she signed this and said that if it wasn't the husband who just passed, it'll be my daughter who's going to be the guardian. It's not, that paperwork is not recognized by the court except as a suggestion when the person who's under the guardianship no longer has capacity to make those decisions. The court's going to assume that when they signed that document, that the legal, the lawyer who put that together knew that they had capacity to make those decisions at that time. If you don't have anything like that in place, then another interested party has to go and start the guardianship process. But they can do it in the same case, in the same court, and just say, I want to be a successor. They'll have to go through the whole vetting process. They'll have to register with the state of Texas and do fingerprints and background checks, etc.
If I'm set up on my parents' bank account as payable upon death, do they both have to die for that to go into effect?
Yes.
Person adds a little backstory.
Okay.
Their mother has dementia. Uh, let's see. Their mother has dementia and their father has Parkinson's and cancer. and will most likely pass before the mother does. The mother has never paid any bills and doesn't manage money well. My father doesn't want to turn over the accounts, so he has only added me as payable upon death. When he dies, I believe her dementia is going to prevent her from making changes, and I will need to jump in.
Then that individual, if your mother did not ever commit any powers of attorney, especially the statutory durable power of attorney, to writing and designated you as a power of attorney, yes, both of the parents have to be deceased before you can have access to that checking account. It means they are probably joint tenants with rights of survivorship in that account. Therefore, the survivor gets the proceeds. You will only be allowed to go into that account if you have a power of attorney for whoever the surviving parent is, if they are incapacitated. That is probably something that obviously she should have taken care of before she got dementia. But at the same time, there are ways that probably have to get a guardianship for mom, not knowing the details of mom's prognosis. But if mom is officially diagnosed as having dementia, then it's most likely you'll have to get a guardianship, and then you will be able to have access to any funds you need to take care of her.
If somebody else wrote in and they would like an example of unsecured debt versus secured debt.
Oh, of course. Secured debt would be your mortgage because they're taking your house as collateral. If you don't pay the mortgage, they take the house. If you don't pay your vehicle note, they take your vehicle. Okay. Unsecured debt is a credit card. They give you that money in the hopes that you will pay it back. If you don't, they can sue you to get that money back, but they have no collateral for that. So therefore, when somebody passes away, their debts, the deceased person's debts are not there. They do not have to be paid by the family or any of the personal representatives of the estate. They have to be paid out of the estate. If the estate has no money, a credit card company is going to have to just forgive the debt or take a very small portion of whatever cash is available in the estate. Another unsecured debt would be, well, oh no, a secured debt would be, let's say, um, I was going to do this backwards. If you have a promissory note, somebody owes you money, that's still enforceable after someone's death. So the executor of the estate can go and still enforce that promissory note. Perhaps your grandmother gave money to a guy to buy a house and she's kept that note and he's been paying all this time. When she dies, he still has to finish paying, or you can foreclose on the house. So that's just the opposite of what you just asked me. But unsecured debt is usually credit cards or anybody else who said oh, maybe it's the guy who came to fix your windows. If he didn't put a lien on your house to fix your windows, which he can in some cases, then he's an unsecured debt also. So those are the kinds of things.
Um, this person is asking, they say that my dog is my family. How can I make certain my dog is cared for if she outlives me?
Absolutely. I actually have a space on my estate planning questionnaires that says, do you have any pets? Who do you want to have them when you're deceased? And do you want to give them any money to help take care of that pet? And then that would be something we would put in the will up with specific gifts that comes out of your estate before it goes to your descendants or whatever. And that gift would go to that individual who you hope will take care of your animal. Sometimes it can be, an organization rather than a person, and you can leave money to that organization or person, and as the payment for taking your pet.
It's my own question in continuation of that. So what happens if there are still funds or assets left after the pet passes away? What happens
Oh,
to those?
I'm assuming what they're saying is that that person still has money left and they've been taking care of the dog, but the dog passes. I would say you'd call that a gift to the individual who took their time and energy to take care of your baby.
Um, and we are almost at the end of our time. So I'm just going to do one last question, which is pretty broad. And it's like, what is the most common mistake people make when planning their estates?
There's actually two. One is not telling the person who's preparing the documents for you everything they need to know. If there's anything that's going to affect how your estate is going to be used or spent or distributed, you really need to tell the person that's preparing this for you so they can help you find ways to organize the character of the asset. So, for instance, if you've got a son who can't not spend money, or a daughter who can't not spend money, and you're not telling the person that, there are ways to help that child of yours that you really love and you want to give them something, but they need a little extra help trying to manage that money. So there's ways to do that by giving a contingency trust, holding money in their account for a couple of years and doling it out to them, having the trustee dole it out to them. Those are a problem that people don't necessarily all take care of. Another thing about an estate plan is not telling the truth about children that are not of the marriage. That because that is going to cause a contest in an estate faster than anything, and everything comes to a screeching halt. So sometimes I have to split up husbands and wives when we talk and ask the husband or the wife, do you have any other children that they don't know about that you need to put into your will? Or that you at least want to acknowledge and omit from your will. But you should never leave out information. If you think it's just going to be glossed over, you're probably wrong, because people will find the money to get an attorney to contest a will. So it's amazing how that happens. I am always amazed by people who can't afford to get their own apartment, but they can find an attorney to help them get dad's house. So those kinds of things. But it's not taking care of the assets themselves and making sure that they are protected against all contest or um, just people that aren't don't have good intentions. So
So you mentioned earlier that you have a questionnaire that people go through
mhm,
when you're helping them plan their
I
estates.
do. It's pretty
Okay.
detailed. Yeah.
So it covers a lot of these things to kind of prompt.
Yes, it does. And it prompts conversation. It prompts them to think about it too, because some people don't think about it. Like they'll say, I want my husband to be my executor. Okay, what if he's not alive when you pass? Who do you want to be the second one? Ooh. They don't think that far. Or if your children aren't alive when you pass, which is a terrible subject, but if your children aren't alive when you pass, who do you want their share of your estate to go to? And they're like, oh, well, I don't want to give it to the spouse and I don't want to give it to the children, the grandchildren, because they're, et cetera, et cetera. And so you walk through these scenarios with people when you do an estate planning questionnaire. So that's my way of finding out what people are hiding. So
Or jogging their creative juices
ex
to think of like a
exactly. Let's
follow
think
the
outside the
story.
box. Yeah.
Okay, we are out of time. We want to be cognizant of keeping our webinar at an hour. Um, Thank you, Kathleen, as always. You always give really great informative information. Just a reminder for everyone that today's webinar has been recorded and it will be available on the HAPS.org website and also on the HAPS YouTube channel. Thank you, everyone. Thank you, Kathleen.
My pleasure.
We're really happy to have you all join us, and thank you so much.
Thank you.